I talk about deferred prosecution agreements, I do feel the necessity to just respond on a couple of points that Professor O'Sullivan has stated. The attorney-client privilege dates back. I mean, it's not only that it's found within a Supreme Court decision like Upjohn, it's not only that it's found in a federal rule of evidence, and it's not only that it's considered one of the landmark things that is a portion of our adversarial system of justice. When the government took away that attorney-client privilege with Form 8300, a form that required an attorney to disclose information about the client if they received more than $10,000 in cash, and then added to it, if it's a suspicious transaction, they had to check off the box. It wasn't when they said that they were going to monitor the attorney-client conversations in a prison, because that was all terrorism. But it's when they start looking at the attorney-client privilege in the corporate sphere that people are suddenly waking up. And I agree that, yes, there has been a lot of notice to this issue, but maybe there's been a lot of talking before this, but some people haven't been listening. The second point I just want to make in response is corporations work for a profit. They have individuals and you have the corporate sphere. And one of the things that you don't want is pitting the two against each other. And when you take away an attorney-client privilege, that's in essence what you are doing. You are sending the message that you are out there individuals and you are out there corporation, and we may be up against each other. That's not the corporate model, and that's not the model that's going to achieve corporate compliance, the eradication of corporate irresponsibility and criminality. So let me start with that point. Now let me move on to what I really am here to talk about, and that is deferred prosecution agreements. Deferred prosecution agreements and non-prosecution agreements have become something that we see has been on the rise. In the years of 1993 to 2008, Lawrence Finder, Ryan McDonald, and Scott Mitchell reported that there were 112 deferred prosecution or non-prosecution agreements. Now, during 2007, there were 40, a third of which were based upon the Foreign Corrupt Practices Act. That number was reduced in 2008 to 16, of which 7 were based upon the Foreign Corrupt Practices Act. I'm not certain that number is going to remain as low this next year, and it may go back up, because there are some clear benefits to a deferred or a non-prosecution agreement. Now, the deferred prosecution agreements, we can look at those back in state court in the juvenile system. The kid commits something that's an illegal act, you don't want to ruin their life, give them a second chance. Maybe it'll get expunged from their record. Defer the prosecution in some way. Help them out. After all, they're young. Taking that same model, it keeps the corporate structure, it keeps them alive by having a deferred prosecution agreement. In addition to that, it's going to avoid costly trials. There's going to be a lot less harm to innocent employees. We're not going to see the Arthur Anderson, and yes, maybe it won't always be Arthur Anderson, but the stigma of a corporate indictment is still there, and the public will see it. We want them to see it, because after all, if we're going to achieve deterrence, don't we at least want the name out there? There's also going to be less harm to third parties. The stockholders are going to suffer less if you have a deferred prosecution agreement. And one of the most important reasons, especially if you're dealing with defense procurement, if you're dealing with the healthcare industry, you're going to avoid that debarment or that exclusion by having a deferred prosecution agreement. Now, it isn't all good. There are many objections that have been made to the use of deferred prosecution agreements. The most obvious one is the lack of transparency. You don't see a website on the Department of Justice that lists all the deferred prosecution agreements. And as was told us earlier today, in many instances, the corporations don't want it. They don't want it known that they have been charged with some type of criminality. There's also a lack of consistency in the process, because in many instances, you have no part in it. You may be accepting that deferred prosecution agreement, but if it's a non-prosecution agreement, you don't see it, you don't have any control, and you cannot, in fact, provide the oversight that may be necessary. The final thing that I see as a general objection out there to deferred prosecution agreements goes to the specifics of the agreement itself. And that is that many of these agreements have contentious aspects to it. I want to look at just a few of what I consider to be the unacceptable provisions. Some of these are provisions of the past that we may not see in future type agreements. The first one, and I do consider it objectionable, is the requirement to waive attorney-client privilege. And the fact that they no longer are going to ask reminds me of the don't ask, don't tell policy. We all know it, it's there, the elephant's in the room, give it to us. But just don't, we're not going to ask you for it. As long as there is some benefit accrued by giving it, it's there. The present policy of removing some of that is a step in the correct direction. But personally, I think that the Specter bill will provide more. The requirement of waiving that attorney-client privilege serves as something that is detrimental to our system of justice. This isn't about a corporation. This isn't about the individual. This is about what we stand for and the type of judicial system that we stand for. The second thing that I think is a very unacceptable provision in some of these deferred and non-prosecution agreements is that if there is a breach of the agreement, the government gets to decide there's a breach, and only they get to make that determination. It is within their sole province to say, you in fact breached this agreement, the agreement's no longer in effect, we can prosecute you, or we can take the remedies against you. This is an unconscionable agreement. And finally, one of the last provisions that I find to be just truly unconscionable is that if you don't abide by previously negotiated contract terms that allows the corporation to pay the attorney fees or the corporate employees. Now that's fine. I'm not so sure I want the corporation paying the fees of people who have committed crimes. That may not be a very good thing for a corporation to be doing. And I hope that boards of directors across the United States start looking at that. But as long as it's in the contract, as long as it's an accepted policy of that corporation, I don't think the government ought to interfere. There's something wrong when the government has the power to come in there and interfere with a contract term that was negotiated by the parties. The problems that these terms raise are ethical, constitutional. It negates the basic tenet of the evidentiary structure of our legal system. It also removes the objective decision maker it interferes with the private contract right. They're agreements that are under economic duress and basically procedural and substantive unconscionability. Now, there's a certain amount of unconscionability in many contracts. When a person pleads guilty, there's a certain amount of unconscionability there, but we advise the individual of what rights they're waiving. There are many acceptable provisions within these deferred prosecution agreements. Important things that we can achieve eradicating the improper conduct that may be occurring out there. In every agreement, you see that you have to abide by the law. That's great, that's wonderful. In most agreements, you're going to see that they're going to put an internal monitor in effect for oversight. And in many agreements, you're going to see that there's going to be a fine for prior wrongdoing. These are all terms. They correlate with the kind of terms that a judge would use during sentencing. They correlate with our typical plea bargain terms. What I'm going to suggest is that we need to start reevaluating these deferred prosecution agreements and these non-prosecution agreements, and we need to use basic contract principles. We use the contract principles in plea bargains. Why not use them with these type of agreements? There are a few updates I also want to talk about. In November 1st, 2006, the removal of the attorney-client privilege waivers was in the sentencing guidelines. According to the sentencing guidelines now, you cannot ask for that attorney-client privilege in order to get that sentence reduction in the federal system. Also, corporations get credit now for disclosure of facts, regardless of waiving the attorney-client privilege. Additionally, prosecutors cannot ask for that non-factual attorney-client privilege material, what they call the Category 2. The Morford memo deals with the selection of monitors. This is a step in the right direction. The appointment of monitors was somewhat haphazard. The appointment of monitors, and I tell you all out there as judges, I don't have a chair right now. I just want you to know that. I was disappointed maybe that the Morford memo said, and the DOJ policy now says, that you can no longer give ethics chairs to law professors as part of the deferred prosecution agreement. It just happened, and it was disappointing to see that put in there, but on the other hand, quite frankly, that's what needed to be put in there. We can't have deferred prosecution agreements that are going to be giving benefits to third-party individuals unless there really is some correlation. If the individual is going to be doing something, in other words, to help out the corporate situation and to correct what is going on there. We've got the Specter bill that Professor O'Sullivan talked a little bit about. It's going to prohibit federal prosecutors and investigators across the executive branch from requesting or conditioning charging decisions on an organization's reasonable assertion of attorney-client privilege or decision to pay attorney fees for an employee. Why should we pass this? Well, I think that they should pass this because it puts in a legislative layer as opposed to just a DOJ policy. And as many of you know, DOJ policies are policies internal to the Department of Justice and not necessarily enforceable at law unless, of course, you're going to use supervisory powers to do it. So having something on a legislative level will bring to a higher standard and make certain and send a message to prosecutors that this is an important right and that's something that should not be taken away. Some of the things that have come up recently, some of the cases show the problems that are arising as a result of waivers of the attorney-client privilege. And I want to talk about some of these front-end issues. One of the issues that's coming up is the corporate counsel goes into either the SEC or into some place that they are being questioned, into the agency doing the questioning, with the employee. And the corporate counsel may tell the employee, I'm not representing you, or the corporate counsel may say nothing. Or the corporate counsel may say, well, we've dealt with each other in the past, you don't really need an attorney here. Or the corporate counsel may be very upfront and say, I am not representing you, I am representing the company. There's a lot of distinction between that because in many cases you might not have the most sophisticated individual, someone who's been relying on that corporate counsel for the last 10 or 15 years every time there was a legal problem in the company. And that individual goes in to that hearing, and that individual, whether it be a CFO of broadband, whether it be somebody who is out of the Stanford case. I mean, these are some of the cases that are coming up recently where the who question becomes a serious matter. Who is that individual representing? And without the attorney-client privilege, it becomes a monumental issue. And it becomes not only a monumental issue for the individual, but it is now becoming an issue for the corporation. You're having situations where the corporate counsel is now being questioned. Did they properly advise the individual? Should they have gone in there? Should outside counsel have been appointed in that situation? And it comes out of the effect of that attorney-client privilege. There may also be the situation of the material that's gained from that corporation. Is that material going to be subject to discovery? And we've got some recent decisions out there. U.S. v. Williams just came out in the past couple of weeks, where the government is saying, well, wait a minute, we received this material from the corporation, and the third party is coming in and saying, we don't want this disclosed. It's attorney-client privilege material. So opening up the attorney-client privilege this way can have ramifications to a corporation. And I think the corporations are going to start realizing this, that maybe this is something they have to think about, and maybe when their back is against the wall and they feel the necessity to give up everything in order to get that non-prosecution or deferred prosecution agreement, they have to think about what the ramifications are. So my thought in conclusion, there's a lot going on out there, and there's a lot without a lot of transparency right now. And there's a lot that I think will eventually trickle down to the states. So I think it's something to watch. I think we need to have a lot more conversation about what's going on. I'm not too quick to say I want to throw the attorney-client privilege out, nor am I so quick to say I want to throw out corporate deferred prosecution agreements and non-prosecution agreements. I think it's all good. Just think sometimes we have to think about the way it's being done, who's doing it, and make sure that there is transparency so that we all know what's going on. Because with that transparency comes deterrence. Thank you.